The sound of gunfire echoed through the Tree of Life synagogue in Pittsburgh on an October morning in 2018. Worshippers scattered, police rushed in, and chaos filled what had begun as a quiet Shabbat service. The man behind it was Robert Gregory Bowers. He was born in 1972 in Baldwin, Pennsylvania. He grew up in a working-class neighborhood. His early years were shaped by tragedy. At the age of 7, he lost his father, Randall G. Bowers. Randall passed away while waiting for a court case. This event left a lasting mark on Robert's childhood. As he grew older, Robert was seen as quiet and withdrawn. He went to Baldwin High School but left before finishing. In his adult years, he worked as a truck driver for more than 10 years. This job kept him away from regular social life. Neighbors often described him as a ghost. He rarely interacted with people and preferred to stay by himself. Behind this isolated lifestyle, Robert carried strong feelings of resentment. His online activity revealed that he was deeply influenced by extremist beliefs. He openly expressed negative views about Jewish communities and immigrants. He often posted these ideas on a platform called Gab, which was known for hosting extreme content. On October 27, 2018, Robert entered the Tree of Life, or La Simcha congregation in Pittsburgh, Pennsylvania. It was during Shabbat morning services. He was carrying firearms and targeted the worshippers inside. He shouted hostile words against Jewish people as he acted against members of the Tree of Life, Dor Hadash, and New Light congregations, who all shared the building. 11 worshippers lost their lives that day, and 6 others were hurt. Among the injured were 4 police officers who had responded to the scene. Robert exchanged gunfire with officers before eventually surrendering. Investigators later discovered that, just before entering the synagogue, he had posted on Gab. In that post, he wrote about his anger toward Hayas, a Jewish nonprofit that helps refugees. He claimed he could not stay silent any longer. His words showed that he believed in conspiracy theories about threats to his race and religion. After his arrest, Robert was charged with many federal offenses. These included 11 counts connected to obstructing religious freedom, 11 counts classified as hate-related, and several additional charges for using firearms and causing harm to law enforcement. His case went to trial in 2023. During the trial, the prosecution showed detailed evidence that Robert had carefully planned his actions. They presented his long history of online activity, filled with anti-Semitic posts and extremist support. His defense team, on the other hand, argued that he had severe brain damage and mental illness, and they tried to reduce his responsibility. The jury deliberated for several weeks. They found him guilty on every charge. In August 2023, U.S. District Judge Robert Colville gave him the most severe sentence possible. The judge described the event as extremely cruel and noted that Robert showed no sign of regret. Families of the victims and survivors also gave statements in court, speaking about how the tragedy had permanently affected their lives. Robert showed little emotion while the sentence was announced. When he was given the chance to speak, he remained silent. His silence stood in contrast to the emotional words of the families, who expressed both their pain and their desire for justice. As of August 2025, Robert Bowers is still being held at the U.S. Penitentiary in Terre Haute, Indiana. He is on federal row, awaiting the government's final decision. No date has been set for his sentence to be carried out, and it is uncertain when or if that will happen, given the long and complex process of federal cases. The next man had no history of serious crime. So how did he end up planning one of America's most notorious church shootings? Dylan Roof was born in 1994 in Columbia, South Carolina. He grew up in a modest household, but his childhood lacked stability. His parents separated when he was young, and he lived with his mother in Eastover, a town with a mostly black population. Roof struggled in school. His grades were below average, and he attended several different schools. In 2011, he left high school without graduating. His social life was also limited, and he often kept to himself. He had issues with substances, including pot and prescription pills. Even with these struggles, he had no serious record of wrongdoing before the church incident. In the years before the event, Roof became deeply involved in online groups that shared racist views. He spent time on websites that spread these beliefs, and over time, his resentment toward Black Americans grew stronger. He wrote a manifesto online, where he revealed his plan to spark conflict between races. Roof carefully prepared. He legally bought a .45 caliber Glock handgun. This purchase was possible because of a mistake in the FBI's background check system, which failed to block the sale even though he had a past substance-related arrest. On the evening of June 17, 2015, Roof went to a Bible study at the historic Emanuel African Methodist Episcopal Church in Charleston, South Carolina. The church, often called Mother Emanuel, is one of the oldest black churches in the country and has a long history in the civil rights movement. Roof sat with the group for about an hour, taking part in conversation and prayer. At around 9 o'clock, he stood up, took out his handgun, and opened fire. 9 church members lost their lives, including the pastor, State Senator Clementa Pinckney. One person, Polly Shepard, survived. She later testified in court and described how the shooting began as everyone was standing to pray. Roof's actions were fueled by his hope to cause racial conflict. In his online manifesto, he said the 2012 shooting of Trayvon Martin was a turning point that shaped his hatred. He believed that by targeting a black church, he could start a larger racial confrontation. When police arrested him, he said he felt he had to go through with it, showing no regret for his choices. Roof's trial began in December 2016. He faced 33 federal charges. These included hate-related offenses and obstruction of religious practice that resulted in lives being lost. Prosecutors presented strong evidence, such as his written confession and his online manifesto. His lawyers argued that he should receive a life sentence, pointing to his age and mental health struggles. The jury, however, reached a decision in only 3 hours. They unanimously recommended the highest penalty available. On January 10, 2017, Roof was formally sentenced. It became the first case in the United States where a person received capital punishment for a hate-related act. During the sentencing, Roof spoke to the court. He said, "I still feel like I had to do it." He showed no sign of regret. As of August 2025, Roof is still in prison. His lawyers have filed a 321-page legal brief. In it, they argue that mistakes in the trial process should overturn both his conviction and sentence. This appeal is still ongoing, and the case continues to develop. The next man wore the same uniform, saluted the same flag, and then turned his weapon on his own. Nidal Malik Hassan was born in 1970 in Arlington, Virginia. He was a U.S. citizen with Palestinian roots. Hassan grew up in a Muslim household. He chose to study medicine and later became a psychiatrist. Over time, his family background and personal upbringing have been closely examined to understand what may have shaped his later choices. On November 5, 2009, Major Nidal Malik Hassan, who was serving as a U.S. Army psychiatrist, carried out a shooting at the Soldier Readiness Processing Center in Fort Hood, Texas. The incident went on for about 10 minutes. During this time, Hassan ended the lives of 13 people and injured more than 30 others. He was eventually stopped by a civilian police officer named Sergeant Mark Todd. Most of the people harmed were soldiers who were preparing for deployment. Hassan used a .357 Magnum revolver during the shooting. Witnesses reported that he shouted "Allahu Akbar," which means "God is great," right before he began firing. This suggested a possible religious or ideological reason, although the exact motive remains debated. In the years before the shooting, Hassan's behavior had raised concerns among his co-workers. He had been in communication with Anwar al-Awlaki, a radical cleric connected to extremist groups. Hassan also expressed strong anti-American views and made remarks that appeared sympathetic to extremist jihad. Some experts believe Hassan's actions came from a mix of personal frustrations and extreme beliefs. He reportedly saw his upcoming deployment to Afghanistan as conflicting with his religious views. This may have created internal struggles that contributed to what happened at Fort Hood. In 2013, Hassan was put on trial by a military court. He chose to represent himself, but gave no defense. The court found him guilty of 13 counts of planned offenses and 32 counts of attempted planned homicides. The jury took only 2 hours to agree on a punishment. They recommended the highest penalty available in the military system. During the trial, Hassan openly admitted to the shootings. He said he was on the wrong side of the U.S. Army and claimed he had switched sides to support the Mujahideen. He also refused to make a final argument or provide any evidence to lessen his punishment. On August 28, 2013, Hassan received a sentence of capital punishment. He was moved to the United States Disciplinary Barracks at Fort Leavenworth, Kansas, where he remains. In 2023, the U.S. Court of Appeals for the Armed Forces upheld the sentence. In March 2025, the U.S. Court of Appeals, Supreme Court denied his last appeal, clearing the way for the military to issue a possible execution warrant. The next man was described as quiet and awkward. But behind the silence, years of obsession and preparation were unfolding. Richard Wade Farley was born in 1948. His father was in the military, so the family moved often. He spent much of his adult life in California. Farley joined the U.S. Navy and served for about 10 years. After leaving the Navy, he worked in private industry. By the mid-1980s, he had a steady office job at ESL Incorporated. This was a technology company in Sunnyvale, part of Silicon Valley. Farley was known as quiet and socially awkward. He did not have any major record of wrongdoing before the events of 1988. On February 16, 1988, Farley walked into ESL headquarters in Sunnyvale. He was carrying a shotgun and other firearms. Inside the building, he fired at co-workers. In a very short span, 7 people lost their lives, and 4 more were injured. Some were shot at close range while sitting at their desks. Survivors later described how the normal office atmosphere suddenly collapsed into chaos and fear. Farley moved through the building, firing many rounds. He used more than one weapon during this time. Police negotiators were called in, and after a long standoff that lasted hours, Farley finally surrendered. The event left the community shocked and many families deeply affected. This incident did not come out of nowhere. For about 4 years before it happened, Farley had been fixated on a coworker named Laura Black. He wrote letters to her, left gifts, and appeared without invitation. In February 1988, Laura Black obtained a temporary restraining order against him. A hearing to decide if the order would become permanent was scheduled for February 17th, the day after the shooting. In the week before the incident, Farley bought a shotgun and large amounts of ammunition. He left a package for Laura Black's lawyer containing fake receipts and other made-up evidence. In it, he tried to show that he and Black had a relationship, though that was not true. His behavior showed a pattern of obsession, repeated attempts to force contact, and then escalation when those efforts failed. Why Laura Black specifically? Farley believed they had a connection, even though she denied it. He wanted her attention. At his trial, he claimed he wanted to make her feel regret. Records from court and reporting show that he relentlessly followed her and then directed his anger toward her workplace. On that February day, Farley arrived carrying several weapons. These included a Benelli Riot semi-automatic shotgun and others. He first fired at a woman outside the doors. Then he entered the building. Some employees lost their lives instantly at their desks. Others were injured and tried to hide. Laura Black was also shot but survived. After a long recovery, she later returned to her job. Farley fired nearly 100 rounds. Negotiators eventually reached him. At one point, he said he wanted Laura Black to live so that she would feel regret. After hours, and after asking for a sandwich and a soft drink, he surrendered. Farley was taken into custody at the scene. He was charged with 7 counts of first-degree homicide and several counts of attempted homicide, along with related charges. The prosecution presented a strong case. They focused on his long, stalking behavior, the letters, the gifts, the weapon purchases, and the package of fake evidence. At trial, Farley admitted to taking lives, but pleaded not guilty. He argued he had not planned to harm so many people, and that his actions were driven by obsession and a wish to end his life in front of Laura Black. Prosecutors countered with evidence that showed planning, such as the timing of the incident, the restraining order hearing, and the preparation with weapons and ammunition. The jury found him guilty of 7 counts of first-degree unlawful loss of life. On January 17, 1992, a judge sentenced him to capital punishment. This started the automatic appeals process that all capital cases in California go through. The court concluded that Farley's actions were pre-planned. The timing of the purchases, the years of letters and unwanted contact, and his choice to act the day before the restraining order hearing all supported that finding. Appeals courts later reviewed and rejected his challenges to the verdict and the sentence. Farley's case moved through decades of appeals. In 2009, the California Supreme Court upheld his capital sentence in People v. Farley. His case was often cited in discussions about workplace tragedies and stalking. The incident also pushed lawmakers to introduce some of the nation's first anti-stalking laws. Farley spent decades on California's capital sentence penalty and was later transferred when the state changed, where inmates under that sentence were housed. In 2024, Santa Clara County District Attorney Jeff Rosen launched a program to review capital cases. He asked judges to replace those sentences with life in prison without parole. Farley's case was included. Rosen argued that this would stop the long and costly appeals process. Some survivors and families of victims reacted with anger and sadness. They questioned why someone who had planned such a brutal act should be considered for a lesser sentence. Hearings followed, giving families time to speak. In March 2025, after hours of victim testimony, a judge ruled that Farley's sentence would remain in place. For now, the capital sentence still stands. The next case shows what happens when the target isn't co-workers, but law enforcement itself. Kyle David Jokel was born in 1985. He grew up in rural Nebraska, living on his grandfather's farm. His upbringing was marked by poverty, instability, and isolation. His family moved around, and he left high school in 11th grade after a conflict with his father, who was a minister traveling often due to financial hardship. During high school, Jokel became a heavy drinker, a common issue in his community, and heating was unaffordable in their home. On August 16, 2012, deputies from the St. John the Baptist Parish Sheriff's Office responded to a series of incidents that led them to a trailer park in LaPlace, Louisiana. Deputies were moving between locations when they suddenly came under fire. In a short but chaotic series of events, 2 deputies, Brandon Nielsen and Jeremy Triesch, were fatally shot. 2 others were wounded. Law enforcement quickly identified several people at the scene. In total, 7 individuals were taken into custody, and several faced charges. Prosecutors eventually focused on 2 men they said were the main shooters, Kyle Jokel and Brian Lynn Smith. Authorities described the incident as an ambush. They said military-style rifles were used, and the gunfire came from multiple spots. At trial, the prosecution gave a straightforward account. They said deputies were drawn into a dangerous situation. Suspects fired from a trailer and other positions, and one of the weapons was an AK-style rifle. Witnesses, including surviving deputies and bystanders, described hearing multiple shooters and said the situation escalated very quickly. Evidence at trial included DNA and blood analysis, ballistics, and physical links between Jokel, a rifle, and the scene. Prosecutors argued that Jokel did not just stand nearby. They said he held and fired a rifle, which directly contributed to the deputy's demise. Defense attorneys did not dispute that Jokel was present, but they argued he never fired. They said Brian Smith and others were the main shooters and pointed out that eyewitness accounts contained inconsistencies. Jokel himself testified. He denied firing a weapon and said he was not responsible. The prosecution leaned heavily on forensic evidence. Reports from the trial stated that Jokel's blood was found on a rifle, and his pants had blood that matched Deputy Brandon Nielsen. This was presented as proof that Jokel was actively involved. Surviving deputies described what they saw. Families of the deputies spoke about the impact of their loss, sharing how the loss of husbands, fathers, and co-workers changed their lives. One of the main questions was whether Jokel fired the fatal shots. Prosecutors said yes. They claimed he armed himself with an AK-style rifle, fired at deputies, and even fired at one deputy who was already down. The forensic evidence, they said, supported that claim. The defense said no. They argued Brian Smith was the shooter, and Jokel was wrongly blamed. After hearing all the evidence, the jury sided with the prosecution. They found Jokel guilty of 2 counts of first-degree charges. During the trial, the defense shared Jokel's background. He grew up in rural Nebraska. Reports described his childhood as unstable. He had limited education and struggles with drinking in his younger years. The defense painted him as someone influenced by others in the group, rather than someone acting on his own intent. Prosecutors presented a different picture. They linked Jokel to people who followed anti-government ideas, sometimes referred to as the sovereign citizen movement. This group rejects government authority and, in some cases, has led to dangerous confrontations with law enforcement. Authorities said the group at LaPlace was connected to those beliefs. Whether Jokel fully shared those views or was swept along by others became part of the debate over motive. The prosecution argued the motive was hostility toward law enforcement. They said the men planned to resist and had prepared for action. Defense lawyers countered that Jokel did not share the same intent and should not be treated the same as others. The jury again sided with the prosecution. Jokel's trial began in February 2020. The jury returned guilty verdicts on 2 counts of first-degree charges after a short deliberation. In the sentencing phase, family members of the deputies described their grief. The defense asked for a life sentence instead of capital punishment. The jury unanimously recommended the harshest penalty. On February 10, 2023, a judge formally imposed that sentence. Jokel was moved to Louisiana State Penitentiary, where he remains waiting for his capital punishment to be carried out. His attorneys have filed appeals, which are still ongoing. Jokel was tried separately from Brian Smith. Smith was also accused as a shooter, but he was found mentally unfit to stand trial and placed in a mental health facility. The large number of people involved and Smith's mental health ruling complicated the legal process. Jurors for Jokel's case were chosen from Rapides Parish because of heavy publicity in St. John Parish. As of 2025, Jokel remains in prison as he handed over the harshest penalty. In 2023, Louisiana faced debates about the capital punishment. His legal status today is that of a condemned inmate pursuing appeals through state and federal courts. In the next case, 5 women went to work at a small-town bank. By the end of the day, none of them made it home. Zephan Xavier grew up in Indiana and later moved to Central Florida in late 2018. People who lived near him described him as quiet and private. His work record was unstable. He tried online courses but did not stay long. He served for a short time in the military. In November 2018, he accepted a trainee position at the Florida Department of Corrections at Avon Park Correctional Institution. Records show he left that trainee role on January 9, 2019, only 2 weeks before the incident in Sebring. Reports about his personal life describe difficult relationships with people close to him. An ex-girlfriend said he had a strong interest in weapons and dark subjects. These details became more public after the events at the bank. On January 23, 2019, a little after noon, Xavier entered the SunTrust Bank in Sebring, Florida. Witnesses said he wore a vest that looked tactical and was carrying a handgun. Inside the small branch were several staff members and at least one customer. Xavier made 5 women lie down on the floor. 4 were bank employees, and 1 was a customer who had come in that day. He fired at them at close range, leaving no chance of survival. Another employee escaped and later gave testimony to investigators and in court. Afterwards, Xavier called 911 and told dispatchers what he had done. He stayed inside the building, blocking the doors. Negotiators spoke with him, and a SWAT team later entered and took him into custody without more harm. The 5 women were identified as Cynthia Watson, age 65, Deborah Cook, age 54, Marisol Lopez, age 55, Anna Pignon Williams, age 37, and Jessica Montague, age 31. Each of them had families, work, and communities that were deeply affected. Later, during sentencing hearings, family members shared how their lives changed forever. Their words became a powerful part of the trial. Investigators later confirmed that Xavier did not know any of the 5 women beforehand. They appeared to be chosen only because they were inside the bank that afternoon. Records also showed some planning. He had left his corrections job earlier that month and came prepared that day. Prosecutors said this showed clear preparation, while the defense argued his long history of mental health struggles played the bigger role. In interviews after his arrest, Xavier made short statements. He told officers he believed he should face the harshest punishment. He also said he had been hearing voices and felt a strong urge to act on them. These statements became central in court, as both sides debated his state of mind. Xavier was charged with 5 counts of first-degree unlawful taking of life. At first, he entered a not guilty plea. The state said it would pursue the maximum penalty allowed under law. The case moved slowly over the next few years, partly due to delays caused by the COVID pandemic. In March 2023, he changed his plea to guilty. This removed the question of guilt and sent the case into the sentencing phase. The jury now had to decide between life in prison without parole or the maximum penalty. The sentencing trial lasted several weeks. Prosecutors highlighted how the women were forced to the ground and shot. They played recordings, showed evidence, and described the harm to families in the small town. The defense presented evidence of Xavier's mental health problems, including a brain tumor and reported hallucinations. Mental health experts testified about his symptoms. The defense asked the jury to give him life in prison instead of the maximum penalty. The jury deliberated and voted 9-3 in favor of the maximum penalty. At the time, Florida law required at least 8 jurors to agree for that outcome to stand. On December 16, 2024, Circuit Judge Angela Cowden followed the jury's recommendation. She described the actions as calculated and cruel. She then formally sentenced Xavier to the maximum penalty, adding the words, "May God have mercy on your soul." Xavier showed little visible reaction in court. By law, the case went into automatic appeal. These reviews are standard in cases with the maximum sentence. The question of motive remained debated. Investigators found no personal link between Xavier and the women. The defense said his mental health history explained his actions. Prosecutors argued that while he may have had struggles, he still made deliberate choices and carried them out step by step. During the sentencing phase, Xavier submitted a handwritten apology. He also made brief comments in court. In earlier recordings, he had told police, "I deserve to die for this." Family members of the women said they did not believe his words showed true remorse. As of August 2025, Xavier remains on Florida's capital punishment while appeals move forward. The sentence has not been carried out. Now shift from a public mass shooting to a private, brutal home invasion that wiped out a whole family. On the night of February 2, 1990, the Parker family returned home after a Bible study. When they arrived at their rural house in Quitman County, they found it completely ransacked. Investigators later said the scene showed step by step how things had gotten worse inside the home. 2 men had forced their way in. They tied up the family. One of them even cut off a finger to take a wedding ring. A 9-year-old child was forced into an inappropriate act. 3 members of the family were then shot. After that, the house was set on fire. Carl Parker, his wife Bobby Jo, and their 12-year-old son Gregory were shot and lost their lives. Their 9-year-old daughter, Charlotte Jo, was still alive after the shooting, but later passed away from breathing in smoke as the house burned. The acts were personal and carried out in a way that showed the intruders wanted to erase the entire family. Investigators later tied the break-in to 2 men, Robert Simon Jr. and Anthony Carr. Physical evidence from the Parker home, as well as items recovered from the men's residences, directly linked them. Forensic testing, including bullet analysis and fire investigation, also placed both men inside the Parker house that night. Things that belonged to the Parkers were found where the men lived, and marks at the scene matched the weapons connected to them. Prosecutors argued this was not just a burglary. They said it turned into prolonged suffering and multiple shootings, followed by setting the home on fire to hide what had happened. Robert Simon Jr. was arrested on February 3, 1990. He was charged with multiple serious counts. The state tried Simon and Carr in different counties to reduce publicity and help with fair jury selection. Simon's trials took place in stages. In one county, he faced charges connected to the passing of Charlotte Jo. The jury there did not agree on a capital sentence, so he received life in prison for that count. Later, in another trial, he was convicted for the passing of Carl, Bobby, Jo, and Gregory. For those 3 counts, he received capital sentences. Court documents and rulings from the Mississippi Supreme Court made it clear that the state pushed for the harshest possible punishment in those trials. When the verdicts came out in 1990, the community was shocked and deeply upset. The loss of the Parker family created a hole in the county that no sentence could truly fill. Still, the process moved forward. Simon was found guilty, sentenced, and his case entered the long path of appeals, hearings on competence, and repeated legal challenges that many capital cases go through. Records show decades of litigation in both state and federal courts, with appeals and petitions that question the trial, the handling of evidence, and Simon's mental state. Simon's time in prison has been defined by ongoing legal battles. One of the most dramatic moments happened in May 2011. A final sentence date had been set, but only hours before it was scheduled, a federal court panel stopped it. The reason was Simon's claim that he was not mentally able to understand the punishment due to a head injury and memory problems. This pause forced courts to decide whether Mississippi had allowed independent doctors chosen by the defense to examine Simon, and whether prison doctors' evaluations were enough. In the years that followed, courts looked at whether Simon's memory issues were real or exaggerated. At one point, a federal judge ruled that Simon was pretending, but his lawyers appealed that finding. Through the 2010s and into the 2020s, the case kept going back to appellate courts. The state tried to reset sentence dates, while the defense argued new points about competence and fairness. By late 2023, the Mississippi Attorney General asked the state's Supreme Court to set new dates for Simon and another long-standing inmate. The state argued that both men had run out of legal options. The defense responded that there were still active petitions, including new challenges about Simon's mental condition and whether he had been properly represented. The court chose to pause scheduling and required the state to respond to the pending issues. This back and forth continued into 2024 and 2025. As of now, Simon remains waiting for his capital punishment to be carried out, with courts still deciding if they can legally go forward. One question often raised is whether Simon acted alone. The answer is no. Court records and reports confirm Anthony Carr was also involved. Both men took part in the break-in, the harm, and the shootings. Evidence at trial tied them both to the scene and to stolen items. Carr was convicted of all 4 offenses and received capital sentences for each one. Simon's punishments varied because different juries made different decisions in separate trials. This shows how the process can lead to different outcomes for the same person, depending on jury choices and trial details. Another common question is why Simon has not been executed after more than 3 decades. The main reason is the legal system's handling of his mental competence claims and ongoing appeals. His defense has long argued that he suffered a brain injury while in prison, causing memory loss and confusion. Courts had to review whether the state allowed independent experts to properly examine him and whether the prison's evaluations were reliable. Sometimes federal courts paused the punishment to allow deeper review. Other times judges ruled against him. The result is a decades-long cycle of rulings, appeals, and new legal questions. That is why his case remains unresolved after so many years. Up next is a man who thought a friend stole from him and then carried out a carefully planned, hours-long act on a household. Richard Kenneth Jerf was born in 1969 in Phoenix, Arizona. He grew up mostly in the Phoenix area. By the early 1990s, he was working night shifts as a custodian. People who knew him during that time described him as quiet and withdrawn. He did not build many close friendships. In early 1993, Jerf became convinced that a former friend and coworker, Albert Luna Jr., had broken into his apartment. He believed Albert had taken electronics and, according to some accounts, even a firearm. Jerf grew increasingly angry when he felt police did not respond seriously to his complaint. That frustration became the driving force behind what he later did. On September 14, 1993, Jerf went to the home of the Luna family in Phoenix. He pretended he was delivering flowers so the family would open the door. Once inside, he forced his way in with a 9mm Beretta pistol, a sharp object, and an aluminum baseball bat. At the home were Albert Luna Sr., his wife Patricia, their daughter Rochelle, who was 18, and their young son Damien, who was only 5. Jerf held the family at gunpoint. He tied them up and gagged them. He ordered Patricia to gather items from the house and load them into a car. These were belongings he believed had once been stolen from him. Throughout this time, Jerf demanded to know where Albert Luna Jr. was. He pressured the family with threats and gave them harsh choices, frightening them in front of one another. When Rochelle arrived home later, he forced her into a room, tied her up, and harmed her with a sharp tool. Not long after, Albert Sr. came home. Jerf lashed on him in the bedroom using both the bat and the sharp object, and then fired multiple shots at him. Patricia and little Damien were also shot at close range. Before leaving, Jerf spread gasoline around the house. He turned on the stove and left a pizza box on the burner, attempting to start a fire. Finally, he took the family's car and drove away. This was not a sudden outburst. It was planned, and it unfolded over several hours. Each step was carried out with intention. So why would Jerf decide to harm a family instead of confronting Albert Jr. directly? Records show that Jerf went to the Luna home expecting Albert Jr. to be there. When he was not, Jerf tried to use the family to force information about his whereabouts. When he did not find Albert Jr., he directed his actions toward those who were there. Prosecutors later emphasized that this choice, to punish the family instead of the person he blamed, made the case especially disturbing. In the days that followed, Jerf told others about what he had done. He even bragged to his girlfriend and to friends, describing the acts in detail. According to law enforcement records, he called what he did really awesome. These boasts reached the police through tips. On September 18th, officers searched his motel room, his car, and his apartment. They recovered stolen items from the Luna home and the weapons he had used. While in custody, Jerf even attempted to take his own life by cutting his wrists with a sharp object. Reports noted this incident in the official record. The collected evidence, combined with the testimonies of those who heard him admit to the acts, created a direct link between him and the Luna household. In August 1995, Jerf chose to represent himself during important parts of the case. He accepted a plea deal in which he admitted guilt to 4 counts of first-degree homicide. The agreement did not remove the possibility of capital punishment. On May 22, 1996, a judge sentenced him to capital punishment. During sentencing, witnesses noted that Jerf seemed defiant. At one point, he even said, "They can only take my life once." The judge observed that Jerf appeared to take satisfaction in the suffering he had caused, which strongly influenced the sentencing decision. After sentencing, his case went through many years of appeals and petitions. His lawyers and later federal courts examined whether he had been competent to represent himself and whether his trial was conducted properly. The case was reviewed many times, but state and federal courts repeatedly denied his appeals. In 2025, after decades of legal challenges, his appeals were exhausted. On August 19th, the Arizona Supreme Court granted a warrant setting a final sentence date for October 17, 2025. State officials announced that it would be carried out by injection using pentobarbital, a standard method in Arizona. The 4 lives lost in the Luna household were Rochelle Lynn Luna, who was 18, Albert Beltran Luna, who was 47, Patricia Luna, who was 42, and Damien Javier Luna, who was 5. The case left surviving relatives and the wider community deeply shaken. For many years in Phoenix, this tragedy was remembered as one of the most shocking family cases in the city's history. Victim impact statements and court records showed how much damage was caused, not only to the immediate family, but also to friends, neighbors, and relatives who were left behind. The event was meant for victory. Instead, The crowd was ripped apart by nails and ball bearings. Dzhokhar Anzorovich Tsarnaev was born in 1993 in Tokmak, Kyrgyzstan. His parents were Anzor and Zubidat Tsarnaev. The family were ethnic Chechens. They left the unrest in the Caucasus region and moved to the United States in the early 2000s. He arrived as a young boy and grew up in Cambridge, Massachusetts. He went to local public schools and later studied at the University of Massachusetts, Dartmouth. His older brother, Tamerlan Tsarnaev, was 10 years older than him and had a strong influence on him during his late teenage years and early 20s. In 2012, Dzhokhar became a naturalized U.S. citizen. On April 15, 2013, at the Boston Marathon, 2 homemade pressure cooker devices filled with nails and ball bearings went off near the finish line. They exploded within seconds of each other among the large crowds of runners and spectators. 3 people lost their lives at the scene, and hundreds were left hurt. Many suffered life-changing injuries, including amputations. The devices were built to spread sharp metal pieces as widely as possible. Photographs and courtroom evidence later showed how the brothers built them, timed them, and placed them near the crowded finish line. The explosions shocked the city and tore through what was meant to be a joyful, family-friendly event. In the days that followed, investigators linked the act to the 2 brothers. On April 18th, an MIT police officer named Sean Collier was shot after being ambushed on campus. Authorities said the brothers were behind it. Soon after, they forced a man named Dun Meng to give up his car and drive them. They later released him unharmed. Not long after, the brothers were chased by police in Watertown. A dramatic firefight broke out on the streets, with the brothers throwing explosives and firing at officers. Tamerlan was hit in the clash and later run over during the escape. He did not survive. Dzhokhar fled on foot. He was later found hiding inside a small boat in a backyard in Watertown. He was taken into custody after being badly injured. Experts later studied the case and concluded that the brothers had been influenced by extremist beliefs. Tamerlan appeared to be the one more deeply drawn into those ideas. He had traveled to the Caucasus region before the marathon and was already under scrutiny from authorities. Dzhokhar, younger and more impressionable, followed his older brother's lead. Court records and intelligence reports said the brothers acted as a form of retaliation for U.S. actions in Muslim-majority countries and were inspired by extremist propaganda. They were described as being self-radicalized, acting on their own rather than under direct orders from a foreign group. Investigators confirmed that Dzhokhar did not act alone. His brother played a leading role in building the devices and guiding him, but Dzhokhar still assisted in making them, placing them, and taking part in the events that followed. The court treated him as an active participant in a joint plan with his brother, not as someone who acted independently. When he was captured on April 19th, Dzhokhar had several serious wounds. Medical testimony later described those injuries in court. Soon after, the federal government filed a lengthy indictment against him. The charges included use of a weapon of mass destruction causing loss of life, conspiracy, and property destruction linked to the explosions and subsequent acts. The indictment described in detail how the brothers prepared the devices, the materials they used, and the steps they took. In 2015, his federal trial began. Prosecutors presented physical evidence, photographs, surveillance footage, forensic analysis, and digital records. Experts explained how the bombs were built and how the metal fragments caused specific injuries. Survivors and families gave emotional testimonies, sharing their losses and ongoing struggles. The defense argued about Dzhokhar's level of responsibility. They highlighted his youth, his brother's influence, and raised concerns about jury selection. Still, the jury found him guilty on all 30 counts. The sentencing phase focused not on guilt but on punishment. In June 2015, a jury recommended the capital sentence for 6 of the charges, and the judge confirmed it. That sentence did not end the case. In 2020, a federal appeals court overturned the capital sentence, citing issues with jury selection and trial procedure. But in March 2022, the U.S. Supreme Court reversed that ruling and reinstated the capital sentence. As of 2025, Dzhokhar remains in a supermax facility. The appeals process has lasted many years. Defense teams raised concerns about juror honesty during selection, as well as restrictions on Dzhokhar's communication and access to certain materials. These issues became central in the appeals. The Supreme Court eventually decided that those errors did not require a new sentencing trial. At his sentencing in June 2015, Dzhokhar spoke publicly for the first time since his arrest. His statement was brief. He said, "I would like to now apologize to the victims and survivors. I am sorry for the lives that I have taken, for the suffering that I have caused you, for the damage that I have done. Irreparable damage. I ask Allah to have mercy on me, my brother, and my family. I want to ask for forgiveness from Allah. These words drew different reactions in the courtroom. Some felt his apology came too late, while others focused on the impact of his actions rather than his statement.